Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. I am your host on this, a broadcast of Civic Media, both this hour and next hour here on all the broadcast stations of Civic Media. Delighted and honored that you have chosen to spend some of your time this weekend in conversation with me and with my producer, Max. As always, in this hour and next hour, taking your phone calls, your questions, your inquiries at 855-752-4842, 855-752-4842. Max always reminds me that you can also drop one of those questions or inquiries into the chat box here at Civic Media, and we will attend to those communications from you as a part of our weekend broadcast, Amicus, a law review. As always, taking our name from the Latin and also the legal term amicus, amici, amicus, a law review coming from the notion of a friend of the court, providing information, insight, perspective, something about the world that may be helpful in terms of decision-making, of resolving issues before us, not only in courts, but also in our lives and our livelihoods. Delighted and honored once again to have you be a part of our broadcast on this weekend. As always on Amicus, a law review, the last broadcast of the calendar year. For this broadcast program, we're going to be talking a lot about the current news events of just this past week. And then as a teaser, a program note into our second hour. As promised last broadcast, we're going to spend some time talking about 2024 year in review. Yes, indeed, lots of programs out there in the media spending time focusing on the significant things that have happened in our lives and in our livelihoods in these last 12 months. We'll be focusing on some of the major issues in the areas of rule of law and government and the aspiration for justice, which is our mission, our purpose here on our broadcast, talking about 15 or those that have animated us during this past calendar year. And of course, also taking your ideas and your comments, your inquiries, your questions about those and other matters that could fill a list of probably 150 significant rule of law stories from just this past year. We have limited them to 15 in the interest of time and focus, spending a lot of our time in our second hour talking about those. And then also starting our broadcast this weekend by talking about those major government and rule of law and justice related stories on our syllabus. As always, it is ambitious, but it is achievable as we together work through all of those significant news stories. What are those events that are going to highlight in our first hour, our discussion? First of all, we're going to talk about something that happened early this past week, and that is the latest decisions by our current president. His name is Joseph Biden, and he has commuted the sentences of 37 additional federal defendants, people on death row. We're going to talk about commutation once again, the difference between that and pardoning individuals who have suffered criminal convictions in our federal system. We'll talk about why these are especially important and why in many ways it is a living up to the commitment he made during his campaign in 2020 on the death penalty, to begin not only to pull back from a history of death penalty impositions in our nation and in our states, but also to live up to that commitment about justice in America. We'll talk about what he has said in commuting the sentences of 37, virtually all, not quite all, but virtually all of the defendants on death row in the federal system. Important to emphasize that, because of course a president can only pardon those people in federal custody under a federal judgment, not a state sentence. We'll talk all about that. We'll talk also about the environment. Three major stories from just this past week. Again, the current President Joe Biden announcing some goals, announcing some grants of monies, even in his waning days as the president, to ensure that our future air, the air we breathe, that we consume here in the United States, and yes, of course, derivatively, we're all in this together across the globe. Every nation, every person on the face of this planet. We'll talk about the goals that he has established that should bring us into 3035 if indeed future presidents, including the next president, were to decide to follow up on those goals for clean air, addressing greenhouse gases, some major announcements that he made just this past week. We'll talk also in the area of environment about a major case coming out of the state of Montana, a Supreme Court case, a decision affirming a lower court judgment, a trial court judgment entered after 16 youth, young people, yes, with a lawyer, but young people brought into the court there in Montana a petition under the Constitution of Montana that resulted in a major finding, the first time in the United States history that a court has found a constitutional right to have legislation introduced that is sensitive to and responsive to the environmental needs and interests of the population. And finally, we'll go back to New York and talk about Kathy Hochul, who, of course, is the governor of the state of New York, and talk about something that she also announced just this past week in the area of greenhouse gases. Greenhouse gases also animating something that happened in New York. We'll talk about that as well. All of that in the area as 2024 begins to come to an end. A lot of focus on the environment as well, for good reason. Necessarily needs to continue well into the new year as well. And we will see. We will continue to monitor on this broadcast and others of Civic Media exactly where we are in this all-important issue, arguably the threshold issue to all the rest of them for the future of humanity, the future of our nation, the world, and all of its residents. Coming back to the United States of America, we're going to talk about a major report just released about the state of homelessness in America and talk about some jumps in the numbers that may, in fact, be a bit antiquated, a bit out of date, but nonetheless are reflective of the continuing issues, the continuing challenges that cities, states, and all of us have across our nation when it comes to people who do not have homes in America. We'll talk about the numbers, the increase in those numbers reported in 2024, why those numbers may be a little bit inflated, and importantly, remembering again what the Supreme Court has said in just the previous term about this also equally important issue of homelessness. Finding that under the 8th Amendment to the Constitution, yes, that's the one that prohibits cruel and unusual punishment in all sorts of ways of our lives. Cruel and unusual punishment does not prohibit municipalities and other government leaders from imposing, establishing, and enforcing laws that keep people from congregating in public, keep people from using parks as their homes. We'll talk about homelessness here on our last broadcast of 2024. Then some other news, much in the headlines of recent days, a lot having to do with TikTok. And yes, indeed, that deadline coming up in early January, just days from now, having to do with whether or not TikTok remains a viable and legal, lawful entity operating here in the United States of America. We'll talk about what the Supreme Court is going to do, as we have done before, and the oral argument that they've got scheduled on January 10th, one of the first things they're doing in the new calendar year. We'll talk about what that case is all about. And yes, indeed, our president-elect just this past week weighing in inside that Supreme Court case, filing, yes, indeed, an amicus brief, a friend of the court brief, in which he has gone on record saying that he would like more time to see if he can address issues related to the future legitimacy, the legality of TikTok after the Congress, as you may well recall, in the present Congress, passed legislation that prohibits the continued vitality and activity, the business operation of TikTok, unless it divests from any Chinese connection. We'll talk about TikTok in the news, and then also in connection with the United States Supreme Court, A major report that flew under the headlines much this past week, issued by the leadership of the Senate Judiciary Committee, addressing all kinds of things related to the judiciary in America, including the number of judges pending right now for nomination, the number of judges obviously confirmed by the Senate in these waning days of the Biden administration, what we can look forward to in terms of a future Judiciary Committee that plainly now in the future United States Senate will be controlled, leadership being taken over by the Republicans as opposed to the Democrats in these waning days of the Democratic control of the committee. A major report issued just this past week, almost 100 pages, commenting on the judiciary in America right now and talking in particular, once again, yes, that's right, we cannot escape it because it continues to animate the discussion when it comes to the Supreme Court, talking once again about Clarence Thomas and Sam Alito and other justices on the Supreme Court, reporting on the ethical challenges that they continue to have, additional trips not reported by Clarence Thomas, even in his supplemental filing with the United States government, with the Administrative Office of U.S. Courts. We'll talk about why that report, which did not get a lot of focus this past week in the midst of many other news stories, why it is a major rule of law story. It is one of the last times, at least for a while, that the Democrats in the Senate will be voicing their views about the United States judiciary and commenting once again on this absolute need for us to have a viable and enforceable rule, a code of ethics for the United States Supreme Court. And then, time permitting, a little bit more about South Korea, what's going on there, and the latest rule of law actions by the Congress there, the National Assembly, what it has done just in the past couple of days, hours actually, impeaching now the acting president. All of that, of course, coming, as you well know, in the wake of the decision by the previous president, also subject to impeachment, also subject to judicial review in that nation pursuant to their processes, also being subject to review by the population of that nation that has risen up in the wake of that very, very inappropriate and arguably unconstitutional attempt by the former president to establish rule of law in Seoul and other cities and places around the nation of South Korea, a democratic republic. What happened just recently in that nation that also animates the news of the rule of law just this past week? It is an ambitious but nonetheless an achievable agenda here on Amicus, a law review. And as always, Max and I inviting your questions, your inquiries at 855-752-4842. Be a part of our discussion on this, the last broadcast here on Civic Media of Amicus, a law review. Stay with us for more of our discussion this weekend. is Amicus, a law review. My name, Jim Santelle, your host for this hour and also next hour here on the broadcast stations, inviting you as always to be a part of our broadcast. It is the final one of this calendar year, but we're going to continue an early program note about what we're doing next week, and that is that on our show on the 4th of January of 2025, we're going to do the bookend portion of what we're beginning in the second hour of this broadcast. We're going to talk about some rule of law issues that are going to be on the docket of all of us in 2025. This broadcast talking about things that have happened in the past. Next broadcast talking about those things that we might reasonably anticipate. And of course, assuming that an awful lot will be unanticipated in the rule of law and justice and government, as has been the tradition recently in the United States of America. We begin this weekend in our broadcast talking about the latest commutations in this broad category of pardons extended by the current president. You may recall well, based upon our previous discussions of this all-important constitutional issue. It is a constitutional prerogative, something vested in the discretion of the chief executive to issue pardons and issue commutations, reprieves, if you will, by virtue of the office of the presidency, established again in the Constitution, written in there by James Madison, passed by the states. And it is one of the very few, if the only executive power that is unchecked, virtually unchecked by any other branch of government. That in part is why it is so controversial, but it's also giving rise to an awful lot of activity in this administration, as it has in previous administrations of all varieties and all sides of the political aisle. Just this past Monday, President Biden commuting the sentences of nearly all prisoners on federal death row, sparing the lives of 37 men just about a month or so before he leaves office. Now, once again, you recall well, a pardon wipes out a conviction, doesn't remove it from the books of history, but does take it off of the official records and rolls and documents of the official judgments in courts. A commutation, however, leaves the guilty verdict, leaves the judgment, the criminal judgment in place, but reduces some or all of the punishment. And that indeed is what Joe Biden has done just this past week in commuting, not pardoning, commuting the sentences of 37 people, all of them convicted of murder, and reducing the terms of the judgments previously imposed upon them of execution, the death penalty previously imposed upon them in the federal system, reducing those sentences to life without the possibility of parole instead of facing execution. None of these people going to see the light of day. None of these people going to be released from the Bureau of Prisons, but they will no longer be subject to execution. And you may recall well that this was a big topic of discussion in the 2020 campaign when Joe Biden was presenting to the United States his position, his view, the federal death penalty should in fact be a part of our past. Now, the Supreme Court, as I made reference to already, has said that under the Eighth Amendment, a number of cases under the Eighth Amendment, the Supreme Court tells us it is not cruel and unusual punishment to pursue the death penalty. And that's why we have around the country a patchwork of different approaches on this issue. Some states where the death penalty is in fact imposed, some where it is not. In the federal system, of course, once again, that is a decision made by judges and juries during the course of the federal process. But up to now, there have been 40 people right now on death row facing federal execution. And the president, not only in his campaign of 2020, but also in recent times, has changed his position from what it was many, many years ago when he was in Congress, and said he no longer believes that the death penalty is an appropriate response to criminal conduct. Still remains a very controversial matter. Of course, he said this: I am more convinced than ever that we must stop the use of the death penalty at the federal level. In good conscience, I cannot stand back and let a new administration, he's talking about Donald Trump, resume executions that I halted. And he said that the commutations were consistent with the standard he has imposed for halting executions in cases other than terrorism and hate-motivated mass murder. went on to say, important for him to say this out loud, important for it to be heard by all of us. He said, make no mistake, I condemn these murderers. I grieve for the victims of their despicable acts, and I ache for all the families who have suffered unimaginable and irreparable loss, acknowledging again the heinous nature of what they have done, and acknowledging that for that, the punishment in the wake of his commutations will now be that they will remain in federal prison for the rest of their lives until the days that they die. Of the 37 men whose sentences were commuted, 15 are white, 15 are black, 6 are Latino, 1 is Asian. They were sentenced in 16 different states, including 3 that have abolished the death penalty. 9 are on death row because they were convicted of killing federal fellow prisoners. In other words, they're in prison and convicted of killing fellow federal prisoners. That also resulted in judgments against them. Who did the president not commute sentences for? The 3 men who will still face federal execution, again, fall in that category that he defined as he described what he was doing. You know their names well because they have been in the stories here on Amicus, a law review, this year and in previous years as well. We remember well the heinous nature, the horrific nature, the murders they committed in cold blood. They're Robert Bowers. He's 52 years old. He was the one in 2018 gunned down 11 worshipers, 11 people gathered at the Tree of Life Synagogue in Pittsburgh. You recall that horrific event and the trial that followed that, resulting in the imposition of the death penalty, the federal death penalty, as to Mr. Bowers. Dylan Roof, he's 30. He is that white supremacist who way back in 2015, what did he do? He went into the parishioners at that church in Charleston, South Carolina, opening fire and killing 9 people. 9 people dead as a result of his hate crime, that horrific murder back in 2015. And Dzhokhar Zarnaev, 31. He is one of the 2 brothers, you may recall, who carried out that terrible bombing of the Boston Marathon way back in 2013, killing 3 people, maiming more than a dozen other people. Continued, like the victims survivors in those other matters, continue to suffer as a result of the terrible, horrific murders that those 3 committed. They are not subject to commutation, in part because their processes will still go forward. They will remain on death row as this president leaves office. And of course, we know that there are other groups out there that are still advocating for this president. He still has about a month or so, a little bit less than that actually, to do more things as the president of the United States of America. He could commute more sentences. He could pardon more individuals. Recall well that a number of days, weeks ago, he commuted the sentences of about 1,500 people, a record one day, 30 of people who again were falling into the category of nonviolent criminals, including some drug offenses, 1,500 people. And of course, the one that didn't start all of this discussion, but certainly began its recent attention by all of us, he pardoned his own son, Hunter Biden, for the violations, his own criminal convictions. Those happened, of course, in the gun case and in a tax case in federal court. All of that happening in recent weeks and recent months as pardons continue to animate our discussion here on this broadcast and throughout America. Stay with us for more of this discussion about the environment too, about what this president is doing here on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle. Thank you for once again joining me in our weekend broadcast, talking about some major issues in this last period of 2024 that continue to affect us and will affect us in the future, not only with respect to rule of law and justice. Just completed our review of what the president has done with respect to commuting death sentences of people on federal death row, 37 of them, not all of them, excluding 3 people, moving now into something else he did just this past week, and that is in the area of environment. And that's going to be a story not only as we close out 2024, but plainly for years to come, and indeed in our discussion next week when we talk about things that we can anticipate into 2025 and beyond. Environment and its intersection with the rule of law, with justice, with government, that will loom large on our syllabus. And join us for that discussion. This week, however, Joe Biden being heard once again on another major issue that he touted during the course of the 2020 campaign, and that has also been a part of his administration for the past nearly 4 years, announcing just on Thursday of this past week an aggressive new climate goal for the United States of America. He says to us that our country should seek to slash its greenhouse gas emissions by at least 61% below 2005 levels by 2035. 3 different numbers there. Important to do the math on all that. 61%, slash it to at least 61% below 2005 levels by 2035. The target, of course, not binding. And yes, I know what you're thinking. You're thinking, well, gee, isn't that the kind of thing that a new president can change? And the answer is yes. These are plainly aspirational goals that he is setting. They're very aggressive, undeniably. A promise of deeper emissions cuts will likely be ignored by the Trump administration based upon what Donald Trump has said in his campaign for the presidency. And in his first term, Donald Trump, among other things, has called global warming a scam. Biden administration officials said that they hoped that by the president announcing this ambitious, but once again, if we all work together, achievable goal, some significant slashes in greenhouse gas emissions in the coming years and decades, hope that would encourage state and local governments, even if the federal government is not a part of this, to cut emissions that are rapidly heating the planet, as we all know, even if the federal government does in fact pull back. This announcement, of course, as I indicated, caps about 4 years or so of climate policies from this president, who has sought to make global warming a signature focus of his administration. Joe Biden, in his announcement of all of this, also described his pumping billions of dollars into clean energy technologies and regulating pollution from power plants and automobiles, describing all of that he has done recently and in the past through legislation that we know well. He described it as the boldest climate agenda in American history. Indeed, it may well be. And he went on to say that American industry will keep inventing and keep investing. He said state, local, and this is the point, state, local, and tribal governments, he said, will keep stepping up. And again, that's a backhand way of saying if the federal government does not follow this encouragement, needless to say, the state, local, and tribal governments can, in fact, do just that. Together, he said, we will turn this existential threat, a threat that goes to our very existence, into a once-in-a-generation opportunity to transform our nation for generations to come. So we've got this new pledge, this new commitment articulated again as aspirational, cutting emissions 61 to 66% below 2005 levels by 2035. That's a very significant update. A very big update from commitments that the United States has already made. In 2021, Joe Biden promised that the country would cut its heat-trapping emissions at least 50% below 2005 levels by 2030. And all of that, of course, aspirational. Last year, emissions were about 17% below 2005 levels, largely because, as we know from reporting on all this, their electrical utilities have retired many of their coal plants in favor of some cheaper mechanisms like cleaner gas and wind and solar power. This year, emissions, according to all of the authorities, are expected to stay roughly flat, in part because some of those rising electricity demands have led power companies to burn record amounts, great amounts of gas, and those sort of offset the renewable energy practices of recent years. You recall well that this is all tied up with that 2015 Paris climate agreement. Each country at that time agreeing to submit a plan for curbing these greenhouse gas emissions, those pledges being updated every 5 years. According to that Paris Pact, which again remains controversial, not just in the present campaign, but look for the future president to remove us once again from that Paris Pact, countries expected to issue a new round of plans before the next United Nations Climate Summit that's scheduled for Brazil in November of next year. All of that as Joe Biden announces these aspirational goals that will long post-date his time in the presidency. It could, of course, also pose much greater challenges for all of us, as not only the federal government likely does not follow that, but the state governments as well try to address these issues. Donald Trump has said that he would pull us out of the Paris Climate Agreement, as he did in the first term. And in a statement contemporaneous with what the current president has said, the indication is that Donald Trump, according to the statement, will, quote, once again deliver clean air and water for American families while making America wealthy again. On Thursday, even as the current president, was announcing these plans, reaffirming the monies that our government has sunk into clean energy and clean air plans, governors taking up much of what the current president has wanted them to do, have a bipartisan group of governors, coalition of governors, 24 different states. They have announced that they would, in fact, work together to try to meet that new goal. Again, that whether the federal government follows that or not. Kathy Hochul, about whom we'll hear in just a moment, she said this new collective goal will serve as our North Star. Our North Star. She's speaking on behalf of a bipartisan, Republicans and Democrats alike, governors out there committed to doing what the president wants wants all of us to do as we continue to address issues of environment in our nation. Some other good news coming out of all of this, and that is some interesting news coming from a Supreme Court in the state of Montana. This is a state court. This is not a federal court. This is a state court, the state Supreme Court. Just this past week, Wednesday, upholding a landmark victory for, yes, indeed, some youthful people, about 16 young people, some minors, minors, who brought a lawsuit challenging the actions of the legislature and not accommodating, not in some way reflecting their concern about the environment in legislative policies. And they brought this lawsuit and brought it to trial a number of weeks, months ago. A case is Held versus Montana. Ricky Held, 23. She is the named plaintiff in the case. She said that when the Montana Supreme Court that issued its affirmance of a lower court ruling, a major movement in support of a future of cleaner environment. Specifically, what did the Montana Supreme Court do just on Wednesday? Upheld a landmark victory, this lower court victory for youth climate activists. They affirmed this decision by a lower court, a trial court judge last year, that the state's energy policies, the things that the administration does, the state of Montana does, violated their constitutional rights to a clean environment. The principal plaintiff here, again, Ricky Held, who's 23 years old now, she said the ruling is a victory not just for us, but for every young person whose future is threatened by climate change. It's a landmark case, admittedly. Once again, it's a state Supreme Court case because it appears to be the first court in the United States of America to recognize a constitutional right to a stable climate. Now, of course, this is invoking the state constitution itself. That's, of course, in the state of Montana, and language that is specific to that constitution. But nonetheless, it establishes this precedent. And the first time, once again, that a high court has made this determination that indeed, under the language of the Constitution, under the law of the state of Montana, individuals, not just youth, but youth focused certainly by this litigation, they have a constitutional right to have energy policies reflect concerns about the future and climate policy in general. All of this, of course, coming as the United States Supreme Court, in cases in the past and certainly in the future, continues to wrestle with the intersection of legislation and of executive action and, yes, indeed, of science, as we all attempt to create a better and safer world. Held versus Montana is the case decided just this past week by the Montana Supreme Court, finding that this climate change issue does have footing, not just in Montana, but presumably in other places, and affirming the constitutional right to individuals, at least to residents of Montana, to have the policies that are implemented by their legislators reflecting concerns about a clean environment, a constitutional dimension. That is no small thing. Held versus Montana. And finally, in this area of environment, which we focus on necessarily in this, the last broadcast of Amicus of 2024, more coming out from Kathy Hochul. We talked already about her affirmation of her interest in supporting other things that the administration is advocating for, this ambitious effort to reduce greenhouse gases in the decade just ahead. Kathy Hochul, once again, the governor of the state of New York, she signed a law on Thursday that does something significant. It requires that companies that are big fossil fuel polluters help pay for repair damage caused by extreme weather, which, again, according to scientists and the people who know what they're talking about, is becoming more common because of greenhouse gas emissions. This is no small thing, once again. This is signing legislation. She is the chief executive, of course, of the state of New York. Signing that legislation, it is now the law. It is now the law. It is called the Climate Change Superfund Act. And yes, indeed, if that sounds familiar, it is premised in many ways upon the federal Superfund law that remains in place, that mandates that companies who are responsible for polluting the environment be responsible for paying for its cleanup in many ways. Superfund sites and Superfund cleanups have been part of our language, our lingo for many, many decades here. This particular act requires that companies responsible for the bulk of carbon emissions, the buildups that happen plainly in the state of New York and presumably other places. As we know, air is not common to just one state. It's common throughout the entire planet, right? Across the United States and every nation on the planet. For the bulk of carbon emissions build up between 2000 and 2024, this new Climate Change Superfund Act in the state of New York requires that they pay about $3 billion each year for the next 25 years, attempting again to remedy in some ways the past sins, if you will, of the environmental damage. And so what Governor Hochul said is this. She said, with nearly every record rainfall, heat wave, and coastal storm, New Yorkers, and yes, she's talking about the people who are electing her, her constituents, people who are not voting for her, but they're all her constituents, right? She's talking about New Yorkers, but basically she's talking about all of us as well, because the things she's talking about plainly impact all of us, not just in the state of New York. She says New Yorkers are increasingly burdened with billions of dollars in health, safety, and environmental consequences due to polluters that have historically harmed our environment. That's significant. That's her mission. That's the purpose, once again, of a legislature that passed this law and that she signed. It is now the law of the state of New York. Again, not unprecedented in terms of the kind of thing that a Superfund Act does, but certainly in recent times, significant that a state now taking its place in this effort to address greenhouse gas emissions. The law, as I indicated, plainly modeled on the original Superfund law that was established way back in 1980, 45 years ago. And that, of course, in the federal system, under federal oversight by agencies, requires company to pay for the cleanup of toxic waste that was accomplished, that was affected by incidents like oil and chemical spills. We've had a lot of those in America, and you have known those based upon your own focus on the news in this area. New York's law, once again, focuses on pollution, according to Kathy Hochul, according to the legislation itself, produced by the combustion of fossil fuels, which again results in warming of the atmosphere, causing extreme weather, floods, storms, and more frequent problems, as she has said. All of that happening in New York in the area of environment just this past week. As we continue on Amicus, we're going to talk about another issue facing us in America now and in the future. Stay with us for that discussion. is Amicus, a law review. My name is Jim Santelle. This is the last segment of our first hour. Appreciating your staying with me and my wonderful producer, Max, as we discuss these major issues that are affecting our lives and our livelihoods in the state of Wisconsin and throughout our nation, across the planet as well. One of those issues, of course, the environment. We've talked about those new Biden goals for the future for decades, years ahead. We've talked about that major Montana case establishing for the first time that, at least in the state of Montana, for the residents there, they have a constitutional right to have their legislators, their policymakers consider climate control, climate issues when accomplishing policy in that state. A major new movement. And in the state of New York, Kathy Hochul, the governor there, not only affirming her commitment to those Biden goals as to greenhouse gas emissions, but also talking about the legislation that she has signed, Superfund legislation in that state, requiring that polluters in that state pay for the pollution they have accomplished. Again, extreme weather, floods, storms, she said, describing the reasons for it. The money raised by New York State under that new legislation signed by Kathy Hochul will do some things that, again, the Superfund site in the federal system, the Superfund site system also does. It funds restoring and protecting coastal wetlands, again, getting that money right back into the environmental restoration, upgrading roads and bridges, improving stormwater drainage systems, all these things plainly having to do with the environment. They're not unrelated to that. Elevating and retrofitting structures there in the state of New York, and investing in recovery efforts from natural disasters, as well as health programs that treat illnesses or injuries that are also related directly to climate change. Again, that connection between the environment, what it caused, what the problems that are caused to the environment by these emissions, and using the monies paid by these producers of the environmental damage, using those monies, $3 billion every year for 25 years, 2000 to 2024, using those monies to accomplish some good there in the state of New York. It is a plan. It is a model that other states plainly can use for addressing the damages already done by climate problems in our nation and in our world generally. All of that happening in these last days of 2024, but plainly the environment continuing to be a major issue into 2025 and candidly for years, decades in our future. Paris Climate Accords also going to be much in the news, as likely the incoming president removes us once again, as he did before, from the commitments made by nations under that pact. All of that, of course, going to be the continuing focus of rule of law issues, because they do intersect so fundamentally with the things that affect our lives. Another issue that falls squarely into that category is homelessness. And homelessness, people without homes, back in the news again just this past week. And we're going to think about not only what a report said about the state of homelessness in our nation, but also the impact of legislation and most significantly decisions by local municipalities and towns and villages when it comes to enforcing rules and ordinances related to homelessness. And a major decision, we talked about it a lot in recent broadcasts here on Civic Media, this major decision by the United States Supreme Court under the Eighth Amendment that told us whether or not municipalities can do things to address the problems, but also the challenges for all of us in addressing homeless populations. Homelessness soared to the highest level on record this past year. It was driven by forces that included high rents and stagnant wages and a surge in migrants seeking asylum. That all according to a major federal government report that was issued just days ago, late this past week. According to that report, which was released by the Department of Housing and Urban Development, sometimes called HUD, Department of Housing and Urban Development, that does these reports every year. And note that, we'll get back to that issue about the timing of this report and whether or not it is accurate as of today. HUD releasing this report saying that the number of people in America experiencing homelessness topped 770,000 people. 770,000 people in America, an increase of about 18% over last year, over 2023. And that's the largest annual jump since this count by this federal agency, by the Department of Housing and Urban Development, began in 2007. That is no small jump. That's no small increase in the number of homeless people in America. Now, once again, the report cited multiple reasons for that rise, and some of those I've already indicated. The end of the pandemic era measures to protect the needy, that's one of them, undeniably. Other things related to high rents, stagnant wages, and migrants seeking asylum, all of those things, according to this report, contributed to the spike in the number of people in America who are homeless. The Biden administration, however, again, a part of its work, it produces this report. HUD is a part of the executive branch, nonetheless says that the role of the asylum-seeking migrants who overwhelmed the shelter systems in this past year are responsible for this increase, this dramatic increase over the previous years. They're focusing on asylum-seeking migrants as one of the reasons why we have an increase and not a decrease or even a flatlining of this number. The Biden administration also arguing, even as it releases this very candid report, says that the annual count occurred last January, about 11, 12 months or so ago, when the migrant crisis had begun to abate, had begun to go away. And so indicating that probably, if their information is to be believed, that when the HUD issues its next report about this time next year in late 2025, the numbers will probably be not as great. We'll see. Again, the Biden administration is saying that the migrant crisis began to abate just as the new year was beginning last year and not fully reflected in the status of things today. And because a nearly year-old record, all this reporting, the argument is that it no longer reflects the current situation that we are presently seeing. Nonetheless, it is significant for America to be mindful of this issue. Nearly every category of unhoused people, according to this report, grew. The rise especially steep among children, 33%, people in families, 39%. The number of people in shelters rose by about a quarter. Unsheltered homeless rose 7%. The rise in homelessness among older adults continued in the same way. A 6% growth in those 65 or over. Those are significant things. Report also found, interestingly, that veterans are the only group, the lone group, that witnessed a decline in homelessness this past year. That continues to be a part of the long-term trend that unmistakably driven by what is a bipartisan support for housing and services for veterans in America. When we come back after the top of the hour break, we're going to talk more about the implications of homelessness in America and move on to other issues that animated the news in the rule of law this past week here on Amicus, a law review on the broadcast stations of Civic Media.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle, your host for this, the second hour of our weekend broadcast, talking about all things government and rule of law and justice related. Thank you so much for spending some of your weekend time with me and my producer, Max. Together, we're taking your phone calls, as always, at 855-752-4842, 855-752-4842. You can also drop a question or an inquiry into the Civic Media box, and we will take a look at that and be responsive to you as a part of our continuing committed to our mission, which is to be a friend, an amicus, an entity that provides information that's helpful to understanding issues of our world. And indeed, that is precisely what animates this, the second hour of our broadcast, the last one of 2024. We're continuing, of course, well into 2025 and beyond as we talk about issues that are important to all of us. And that includes the issue of homelessness. That, yes, indeed, it is a housing issue. It is a social issue. It's a cultural issue. It's a government issue, but it's also a rule of law issue. We know from this report issued by the Department of Housing and Urban Development just this past week, the number of people experiencing homelessness in America, 770,000 people or more, an increase of 18% over last year. Biggest groups, steep increases among children, people with families. People in shelters rose by about a quarter. Unsheltered homeless people rose about 7% over the previous years. Rise in homelessness among older adults continued as well. A 6% growth among those 65 or older. Once again, only veterans saw a modest decline in homelessness. The number of homeless veterans fell by 8% this past year. That is certainly good news, not completely addressing the problem, as long as there is one homeless person in America not being provided in some way, shape, or form with the mechanisms, the capacities to have a home in America. One of the basic tenets of the American dream, having a home, having a residence, a place to call your own. Now, why is this a rule of law issue? Well, it's a rule of law issue because, as we know well, the United States Supreme Court, as have other courts, weighed in on this very issue. What is it that municipalities and other cities and villages and towns, what can they do to address this issue? Of course, one of the things that we have seen is they've passed ordinances around the country that prohibit people who are inhabiting parks and other public places from doing just that. And the question, in a case called Grants Pass versus Johnson, you may recall this. We talked a lot about this past term of the Supreme Court. In that case, the United States Supreme Court, by a divided court once again, 6-3, addressed the issue of homelessness in America. They plainly acknowledged that there is a challenge here, a huge challenge, but they found that, in fact, it is not a violation of the Eighth Amendment of the Constitution. That Eighth Amendment, as you know, prohibits cruel and unusual punishment in all areas. We talked already about it in the context of the death penalty. Here, again, petitioners who are homeless people from the state of Oregon, and in particular the city of Grants Pass, maintain that it's cruel and unusual treatment by their municipality to enforce these ordinances that prevent them from living in these public spaces. And the Supreme Court, again, divided court, a fairly clearly divided court. This is not a close question for the 6-3. One side and the other, taking very different views of this, saying that, in fact, it's not a violation of the Constitution for municipalities to enforce these ordinances, to getting people to move off of those principal areas where the public convenes, including parks and other public areas. That is not without its controversy. But it also establishes plainly, inside this rule of law analysis that we always do here on the broadcast, a basis for understanding what we do next. Because once again, this is one of the things certainly that municipalities now, by virtue of what the Supreme Court has said, they can do this. Indeed, Gavin Newsom in the state of California announced not long after Grants Pass, that decision was decided, that he would move forward with municipalities and villages and towns in enforcing these ordinances, even while, and this is the point, even while inside the rule of law and outside of courts, in the legislatures, in the town councils, in the other mechanisms for representative government in America, including California, including right here in Wisconsin. Mechanisms for addressing the problem of homelessness continued. Nothing about the Supreme Court case says that municipalities cannot do remedial things, supportive things, encouraging, constructive things to address what plainly, according to the Housing and Urban Development Department, continues to be a significant problem and challenge for our nation. It will continue to be that, plainly, as 2024 moves into 2025. This administration, again, through the Department of Housing and Urban Development, reporting on this, but also doing many things in terms of policies to address the issue. With a change in administration, this, like so many other things that we discuss here on our broadcast, also accomplishes a change in policy. Plainly, homelessness, not a major feature of the past campaign, but the Department of Housing and Urban Development has a lot to do with our cities, our municipalities, the ways that they look, the ways that they function, the ways that people live in the 21st century in our cities. That's the whole focus on housing and urban development, where the department gets its name. Huge amounts of money's there. And the question is, how does an administration, how does a Biden administration, how does the incoming Trump administration use those monies allocated in the budget through the Congress to the president through this Department of Housing and Development? How does it do things to remedy the challenges, including homelessness, of our urban locations? All of that remaining to be seen in 2025 as a new administration takes place, as it takes its offices in Washington, D.C., and in other offices, HUD offices around the nation, including right here in the state of Wisconsin, represented them on a fairly regular basis when I was an assistant U.S. attorney here in the Eastern District of Wisconsin. They are a part of our local practice. They're a part of our local areas, and it is the local people, the local officials, those civil servants who do their jobs so faithfully, who are responsible for ensuring that those monies are properly spent, not just in Wisconsin, but throughout the nation. Department of Housing and Development, no small thing, no small feature of our federal government as we continue to wrestle with the issue of homelessness in America. Promised at the start of our broadcast that we would also talk about some other things related to the United States Supreme Court, and that is some news having to do with both TikTok and, yes, indeed, ethics, and Clarence Thomas and Sam Alito once again back in the news this past week. All of that related to our continuing focus on the United States Supreme Court. Let's talk first about TikTok. TikTok in particular. You may recall well, the Congress not too long ago, earlier this year, passed a major ban. Bipartisan support, Democrats and Republicans alike, in response to years of concern, lots of testimony before Senate and House committees, that TikTok's Chinese parent company poses a national security threat to the United States of America because, as the Biden administration maintains, and others have testified to Congress in their own presentations, the TikTok entity, as it is presently owned and operated, can both collect data on users and manipulate that content that the users may see. Not only collecting data, but also manipulating content on TikTok. That was a concern that prompted the United States Congress to pass legislation that bans TikTok come January 19th. Yes, that's right. It's a day before Donald Trump's inauguration. By January 19th, TikTok either goes out of business in the United States of America, banned by virtue of this federal legislation, or alternatively, it can divest. It can divest of any connection to the Chinese parent company, based once again upon this concern by the administration, but also plainly by a bipartisan group of leaders in the United States Congress. That's the House, that's the Senate, that there are national security concerns, a lot of them unrealized, not a whole lot of evidence yet, direct evidence of this happening, but an awful lot of belief that TikTok both collects data on users and also can manipulate that data that the users may see. And that prompted, once again, that's the legislative predicate, that's the rule of law premise upon which the Congress then passes legislation. Joe Biden signed that legislation, not without controversy. And that is the law now, that by January 19th, one of two things happen. Either TikTok goes out of business in the United States of America, or announces that there is a sale of at least its United States, its American component, to a non-Chinese entity. That's all the history that leads up to this. Well, we know as well that TikTok, getting some unfavorable rulings out of the lower courts, trying desperately to stop this from happening, to put it on hold, to find that this is a violation of their First Amendment rights, arguably your First Amendment rights, gone into federal court unsuccessfully to this point, seeking to have the lower courts say, nope, the Congress cannot do this. The Congress does not have the constitutional prerogative, the discretion to limit what TikTok, a voice of people in America and around the world, can do. A First Amendment violation, right to speech, right to advocacy, arguing this is a violation of the Constitution unsuccessfully. And the lower courts saying that no, the national security interests outweigh those interests established under the First Amendment. Not at all an easy thing to debate, because it's highly controversial and reasonable people can differ on this particular notion. Nonetheless, TikTok not being successful up to this point, and petitioning not only for a reversal of what the Congress has done, but also to stave it off, to move it down the road, give them more time. That also has been denied. And therefore, TikTok, as we reported here on Amicus, a law review, TikTok runs to the Supreme Court and says, stop this from happening. And we need you to act very promptly. They filed an emergency application. And indeed, as we have reported previously, the Supreme Court's going to have a hearing, oral argument on all of this. What's going on with TikTok on January 10th? Just a few days from now, not too long, early in the new year, among the first cases it's going to hear oral argument on in 2025 on all of these TikTok-related appeals, including whether or not the deadline date of just 9 days later remains in place or not. Now, what happened? That's all, again, predicate for what happened just this past week, and that is that the president-elect, Donald Trump, is now weighing in on this. We know that the Biden administration has previously filed its brief, arguing once again that national security concerns compel that the court not only support what the Congress has done, that the president signed this legislation, it's good, it's constitutional. The Biden administration taking the position that TikTok needs to go away, at least in America, or divest itself. Donald Trump this past week weighing in on that with an amicus brief of his own. When Amicus, a law review, continues, we'll talk about exactly what Donald Trump is saying to the Supreme Court in this highly topical issue now pending in our highest court as our broadcast continues. My name is Jim Santelle, your host here on Amicus, a law review, talking about these rule of law issues, these justice issues, these court and government issues of just this past week. Donald Trump filing an amicus brief just this past week. A friend of the court, that's his position in his filing to the United States Supreme Court. Many other amicus briefs also being filed by non-parties, asking the court to do various things, expressing their interest, their various concerns about this issue related to TikTok and its future viability here in the United States of America, set to sunset, set to go away on January 19th, the day before Donald Trump takes the oath of office as the next president of the United States of America. Donald Trump, the president-elect, urged the United States Supreme Court just this past week in his filing, again through his lawyers, to pause this controversial ban on TikTok set to take effect again in just a few days. He told the justices in this legal filing late this past week that this delay that he is seeking would allow his administration to pursue a negotiated resolution. He said, I'm going to come into this. I'm going to resolve this in some way. His request is not premised upon a particular position statement, but rather requesting that the Supreme Court hold off on doing anything here and postpone the deadlines here until he can become involved, and plainly cannot become involved until at least one day after the deadline date goes into effect. His request for a delay in implementing the ban puts him at odds, plainly, with the Biden administration, which has defended the law very vigorously in its own brief, saying once again that there would be grave national security concerns about TikTok's continued operation in the United States of America. We've got the position of the present administration, Joe Biden, at odds, or at least seemingly at odds, with what the incoming president has articulated. It's one of the most significant First Amendment cases, again, pending before the Supreme Court. It'd be interesting to see what they do, not only in the weeks just ahead with respect to this looming deadline, but also long-term about whether or not the First Amendment prohibits the Congress from doing what it did. They have to weigh whether the ban that the legislature imposed violates the First Amendment. And the court has already scheduled, as I indicated, this oral argument for January 10th. The court was flooded, quite literally, with other briefs, along with the president-elect's brief on Friday from various groups. They're all seeking to have some say, some involvement in this. This is a friend of the court brief. That's the Amicus, or sometimes called the Amicus brief approach, which also gives our name to our broadcast. But given the fact that the ban is expected to take place on the 19th, all of this takes increased urgency. Now, once again, Donald Trump, in his brief, didn't take a formal position on the underlying First Amendment questions that are proposed and by the present litigation and opposed by TikTok, but instead just asked the court to delay that January 19th effective date, basically sort of accomplishing a legislative fix, if you will, for a while, so that he can come in and presumably resolve this issue. He said this: he wants the additional time to allow the incoming administration to pursue a negotiated resolution that could prevent a nationwide shutdown of TikTok, thus preserving the First Amendment rights of tens of millions of Americans, while also addressing the government's national security concerns. All of that coming in his brief. His brief also went on to claim that he is operating with a, quote, powerful electoral mandate. That's how he described the recent election result, and that he is uniquely positioned to resolve this TikTok controversy. At one point in the brief, he described himself as one of the most powerful, prolific, and influential users of social media in history. Went on to say this. This is in his Amicus brief to the Supreme Court. He said the First Amendment implications of the federal government's effective shuttering of a social media platform used by 170 million Americans are sweeping and troubling. There are valid concerns, he wrote, that the act may set a dangerous global precedent by exercising the extraordinary power, he calls it, to shut down an entire social media platform based in large part on concerns about disfavored speech on that platform. Now, in response to that, the Biden administration took exception to it, and once again, in its own brief, wrote about the grave consequences if this legislation does not go into effect. All of this heightening the stakes in this matter. Will TikTok remain a viable entity, a legal entity, or did it already run afoul, if you will, of the national security concerns that animate the legislation? What is the change in government that's going to happen not before January 19th, but on January 20th, one day before the ban takes place? How does that impact what the Supreme Court's going to be entertaining on January 10th when it entertains oral argument about all of this, including a stay, which is what the president-elect is seeking, and frankly, TikTok's position once again that all of this should be dismissed. All of this should be overturned. The Congress had no capacity, TikTok maintains, to do this in the first place. So Supreme Court put an end to this. Exalt the First Amendment and permit us to continue operating. Others maintaining plainly in the government that national security interests outweigh the extraordinary and considerable benefits of a First Amendment that's alive and well. That's what the Supreme Court's going to be arguing on the 10th day of the new year. Of course, here on Amicus, we'll be reporting on exactly what that is all about and how our Supreme Court justices seem to be lining up in that particular area. Supreme Court continues to be in our news in other ways, and this also related to the interplay between the United States Congress and indeed the Senate Judiciary Committee and the Supreme Court itself. We know well that there has been sparring not only between the United States Supreme Court, some members in particular, Sam Alito, one of the associate justices, maintaining very strongly in public statements of recent years that the United States Congress can impose nothing on the United States Supreme Court in the nature of a rule of law type set of ethics codes, rules, principles, that in itself raises constitutional issues, that the Supreme Court can regulate itself if it chooses to do so, but that the United States Congress can't do that. And the Supreme Court, of course, has done something in response to that. You recall well, we reported on this a little over a year ago that John Roberts assembled what is basically an aspirational set of standards and principles, according to which the Supreme Court should argue, not really an ethics code, but a statement of aspirational principles for when justices should recuse themselves, when they shouldn't, those kinds of things, when they should report on trips and other benefits gotten by them from people who may be practicing in front of them, appearing in front of them in cases in which they're deciding major issues. All of those things set forth in a standard set forth and signed by all the justices. But the problem, of course, no enforcement. Elena Kagan said that we've got to have enforcement of this. Other justices have likewise hinted some enforcement mechanism is appropriate. And yet we don't have that yet. A code of ethics does apply to all the lower court federal judges, the appeals courts that we talk a lot about here on this broadcast, the district courts, the trial courts out of which all these cases percolate from, all of them subject to a very clear and unmistakable set of principles that guide, again, recusals and other things. This past week, the Senate Judiciary Committee once again weighing in with a report, not only on this larger issue, but once again on Clarence Thomas. When we come back, we'll talk more about exactly what the Senate has said about that in this major report here on Amicus, a Law Review. This is Amicus, a law review. My name is Jim Santelle, your host for these remaining segments of our weekend broadcast, the last one of 2024, continuing into 2025. Of course, as one of our major topics has always been, continues to be the United States Supreme Court, the lack of an ethics code that is enforceable, bemoaned by many of us, including members of the Supreme Court themselves, who've talked about mechanisms for ensuring that the Supreme Court's ever-dropping political and public ranking, if you will, the extent to which we rely upon and feel strong about the legitimacy of our Supreme Court continues to drop in America. That's not the only reason for doing it. The more important reason, of course, is to ensure that the integrity is a part of all of the decisions of the United States Supreme Court, that you don't have justices who are deciding cases of their friends in which they have political and economic and social and cultural interests of all kinds. This past week, the United States Senate, through the Judiciary Committee, in one of the last actions of the democratically controlled United States Senate, released a major report on the judiciary, many aspects of this, talking about judges and talking about the ways in which the judiciary has behaved or not behaved in this past year or so. 93 pages of a report, and reveals, in fact, some more things about what Clarence Thomas has and has not reported. It concluded a nearly 2-year ethics investigation, again, by calling on the United States Supreme Court or the United States Congress to establish an enforceable code of conduct, and also identified some recurring problems with reporting by Clarence Thomas, who, of course, is an Associate Justice of the Supreme Court. The 93-page report reveals 2 more additional undisclosed reports that were taken by Justice Thomas in 2021, not so very long ago. Among those, apparently, were a private jet flight to the Adirondacks in July and a lavish jet and yacht trip to New York City in October of 2021, both of them funded by, once again, you've heard this name before, is billionaire Harlan Crow. Harlan Crow had at least one, if not more, pieces of litigation pending derivatively through his companies before the United States Supreme Court. These highlights of this report coming out of the Judiciary Committee just this past week, again, accompany more than 24 other prior reportings by Clarence Thomas, in which he received luxury travel and gifts from wealthy benefactors like Crow and like others, none of which were initially reported in annual financial disclosure forms. And that's the problem. That's the problem. This reporting continues to be problematic. In 2023, the court again did establish this set of guidelines, not enforceable, requiring that all the justices be responsible for reporting these kinds of things. But plainly, even in the wake of that, even in the wake of amending his previous reports, Clarence Thomas was not complete, did not do everything. And once again, we've got these reports of additional reports of his engaging in communications, but also trips, gifts given to him by Harlan Crow in 2021. Things we didn't previously know about, now disclosed by virtue of this 2-year investigation, now concluded by the Senate Judiciary Committee. Dick Durbin, the chair of that committee, saying the highest court in the land can't have the lowest ethical standards. And again, that a part of his continuing advocacy, not only for an ethics code, but also for all the justices to come clean and describe for the American public the sources of all of their income. All of this, of course, rebuked, if you will, by representatives of Clarence Thomas, also rebuked by other people on the Supreme Court, including other justices who have likewise been the subject of focus. Indeed, the report traces the practice of accepting these undisclosed gifts back long before Clarence Thomas and Sam Alito were a part of our national discussion about this. It says numerous trips back to the time of the late Justice Antonin Scalia's term on the court, he established the practice during his decades on the bench of taking reports, undisclosed gifts, undisclosed trips during the course of his tenure. The late Justice Ruth Bader Ginsburg and retired Justice Stephen Breyer, also a part of this report, also took subsidized trips, according to the report, but those justices disclosed them on their annual financial forms, which is now required of all the justices. That's the difference. The investigation, once again, confirming that Clarence Thomas accepted gifts, travel from wealthy benefactors, including Harlan Crow, valued at more than $4.75 million since his confirmation way back in 1991. Much of it just begrudgingly disclosed, if at all. Interestingly, as this recusal issue goes forward, we know that justices can do this on the Supreme Court. Justice Neil Gorsuch recently cited this code of conduct that guides him, at least, when he recused himself for an environmental case. He had been under pressure to step aside due to some potential conflicts of interest. He finally said yes. The court's outcome on that case should not be tainted in any way by my involvement with a Colorado billionaire whom Gorsuch had previously represented before his appointment to the bench. And so justices can do this. They do it. And indeed, Justice Gorsuch, as have other justices, including Sonia Sotomayor and Elena Kagan and Ketanji Brown Jackson, all advocating not only for an enforceable code of ethics, but they themselves following these recusal mandates. All of that coming out, again, from this report issued by the Senate Judiciary Committee just this past week, commenting more generally upon all things justice-related. I commend your attention to, if not the entire 93-page report, nonetheless, some reporting on it, which is important. Once again, Clarence Thomas in the news as 2024 comes to an end because he failed to properly identify and report on his own additional gifts that we did not know about previously. We've spent a lot of time on our broadcast talking about things overseas, and that will continue to be the case in the new year and beyond as well. In South Korea, which we have reported on a lot and commented on a lot about the importance of what the citizens of South Korea have done in the wake of the attempt early this month by the president of that nation, Mr. Yoon, to impose martial law. Lasted about just a few hours and a day in early December. The citizens of South Korea rising up as they continue to do to this day and say, no, we're not going to take that. That is not a part of our mission. That's not a part of our contemplation of what a democratic republic here in Seoul should be and throughout South Korea. And so that has resulted, as we know, in the attempt to impeach President Yoon and his ill-fated martial law bid, setting off a huge amount of turmoil. Those proceedings continue to go forward. Yoon no longer in a position of responsibility. Well, just this past Friday, lawmakers voted to oust a second head of state. Another one, the acting president, the second time this has happened in 2 weeks. And of course, this prolongs this political vacuum that is gripping South Korea since President Yoon shocked the country with this military rule, placing the country under this military rule for the first time in decades. Lawmakers just this past week, again, not only reaffirmed the impeachment of Mr. Yoon on December 14th, but also impeached the acting president, Prime Minister Han Duck-soo. And the reason for that impeachment was because Soo, refused to appoint 3 judges to fill vacancies to something called the Constitutional Court there. That's the body, and that's the reason why this is all relevant, the body that's deciding whether to reinstate or formally remove the president himself, Mr. Yoon. At the heart of the matter, as you can well imagine, then, is how the court might rule on Yoon's impeachment. So 6 or more justices of this 9-member high court have to vote in favor of impeachment in their system to remove Yoon from office. And the court right now only has 6 justices. 3 others retired early this year, according to reports. And the impeachment could be overturned with just 1 dissenting voice in Yoon's trial. That's why the statement, the reinstatement, the naming, the nomination, the placement of more justices on this court is an impediment, if it's not done, to moving forward on all of these impeachments. The failure of the president, the current president, the acting president, Yoon Suk-yeol, or rather Prime Minister Han Duck-soo, in failing to assign and appoint these additional justices. That's what prompted the Congress there, the National Assembly, to move to impeach him now. So now we have 2 impeachments pending in Seoul, in South Korea. All of this adding, again, to the vacuum of power at a significant time with one of Washington's, our own nation's most important allies, country grappling not only with North Korea, the nuclear threats there, economic challenges at home. Not a good time for there to be this vacuum, but nonetheless caused, again, by President Yoon in initially doing this martial law imposition, and the people once again insisting upon a system of government that is responsive to them, that is legitimate, that has integrity. And even in this second impeachment of Prime Minister Han Duck-soo, now serving as the interim president, insisting that he act on the best behavior that he should act on pursuant to that, should be naming these additional justices so that the process can move forward. That's what the people of South Korea, through their elected representatives, are once again asking for. That's what the advocacy is all about. That's why they continue to take to the streets to this day to advocate for a more fair and just and rule of law animated South Korea. We continue to look to them not only to see what happens in that ally of ours in Asia on the other side of the planet, but also as guidance for us about what the way we approach the things that our government does and does not do in present times and in the future. We'll talk about all of that as Amicus, a law review, continues to monitor things in the international arena. Promised at the outset that we would spend the last portions of our time here in this last broadcast of 2024 identifying some of the top rule of law events of 2024. We have talked about all of these. They're local, they're Wisconsin related, they are national, and yes, indeed, they're international. One of them, of course, is indeed this martial law and the consequences of it in South Korea. What are those that I would identify as the top 15 rule of law events of 2024? Let's begin some identification of those right now. At the top of the list, necessarily, once again, our United States Supreme Court on July 1, issuing this major opinion, changing the Constitution that establishes for the first time in our history, as we have so often said, that a sitting president can in fact be immune from prosecution for crimes committed in office. That is colossal. That is catastrophic. Absolute immunity for engagements with the U.S. Department of Justice. It's responsible for the rule of law. We will see how that plays out in the new administration and administrations to come, and whether or not that opinion has lasting viability in an America that, at least up to now, has, like the South Koreans, insisted on more. Insisted that our public officials, including the president, not be above the law. That's a decision that placed him above the law in many ways. Second major rule of law event of 2024, the Trump conviction. Undeniably in that Manhattan court, 34 counts. Donald Trump to this day, even as he looks forward to his own swearing in on the 20th of January, he remains a convicted felon for 34 counts of violating New York law. And that returned again by a jury of his peers unanimously, beyond a reasonable doubt, finding that he violated New York law when it comes to making false statements in records and false representations in those records about the uses of monies to pay off Stormy Daniels in advance of the 2016 election. You know all about that. That conviction, again, going to be the subject of some more attention between now and the 20th of January. We're waiting for Juan Merchan to determine whether or not he will sentence Donald Trump for those counts of conviction or do something else, including either dismissing that case or holding off for 4 or 5 years before doing so. A major rule of law event of 2024. We go back to the Supreme Court for number 3. And that is the SCOTUS, the Supreme Court decision in that Chevron deference case. It's Loper Bright Enterprises. We talked a lot about it. It's the case in which, for the first time in 40 years, the Supreme Court drop-kicked this thing that keeps our agencies representing us and keeps them honest and doing work on behalf of the American population as civil servants, finding that the deference, the decisions by federal courts that should rely upon the expertise of those honest and decent civil servants should be given accord, no longer, according to the Supreme Court. Number 3 on our list of rule of law events. When we come back, the remaining 12 rule of law events of 2024 here on Amicus, a law review. Power Up Here. My name's Jim Santelle. Counting down now the top 15 rule of law events on my list. Maybe they're on your list too. Maybe there are more. There certainly are more that are out there that we've talked about on this broadcast throughout these past 2.5 years. 1, presidential immunity by the Supreme Court. 2, the Trump conviction. The first time in the history of America that a former president has been found guilty of crimes in a state court, in any court. Number 3, that Chevron deference case, finding, again, by the Supreme Court that federal agencies, federal courts no longer have to defer to the expertise, the people who know what they're talking about when it comes to deciding cases before them. Those are huge cases pending before and now resolved by the Supreme Court. We've got more on our top 15 rule of law events list. Number 4, of course, the continuing issue comes out of the decision of a couple of years ago in that Dobbs decision. The continuing work that we've reported on throughout this past year on abortion rights, privacy rights, the consequences of that decision overturning Roe versus Wade in our legislatures, in our referendums, in our courts around the country, causing this patchwork of decisions and policies and practices when it comes to abortion, plainly not yet resolved in America in any way. And indeed, the Supreme Court now entertaining even more cases related to this fundamental right that existed for nearly 50 years before Sam Alito and a majority of the Supreme Court found that that privacy right no longer exists in the Constitution. A major animating rule of law event in 2024. We've already talked about number 5, the TikTok controversy. The Congress deciding that this entity can no longer exist. It is going to overlap 2024 into 2025, as we reported earlier, as the Supreme Court takes up this decision about what happens to TikTok. Our incoming president taking a position contrary to our present president of what should happen there. We've already talked also about number 6 on my list. It's South Korea. The decision by South Korean citizens to rise up and say that they will not tolerate the imposition of this kind of military law in their nation, and impeaching not 1, but 2 of their leaders for failing to do the things that are in the best interests of their nation. South Korea, number 6 on the list. Number 7, elections. One of them positive, one of them not positive. One of them in Mexico, a nation just to the south, the first woman president ever, Claudia Sheinbaum, 65th president of the nation, took office in October of this past year. She was previously the mayor of Mexico, a major milestone that the United States of America has not yet crossed. The Americans have not yet elected a female, a woman. The Mexicans have. Claudia Sheinbaum, first woman president of Mexico. In Venezuela, again to the south, this is A and B of number 7, by the way, Nicolas Maduro in a contested election with Edmundo Gonzalez. Gonzalez almost certainly winning the presidency in Venezuela by a wide margin, according to all reporting. Nonetheless, Maduro accomplishing something that should not happen in the rule of law nations. He is still in office. Gonzalez has fled to Spain. And again, rule of law not active in Venezuela as Maduro basically holds on to power, getting his Supreme Court to certify an election that he did not win. Number 7A and 7B. Number 8, again, Giselle Pellicot. We've talked a lot about her in recent times. This is from France. This is the case in which this icon, this major figure, brought to justice the 50 men who brutally, viciously raped, sexually assaulted her, including her own husband, over a period of a decade, bringing them to justice over a 3-month trial, vindicating the rights that she had, and announcing once again the power of victims to get justice. Imperfect, incomplete for her and her family. Tragedy, undeniably. Giselle Pellicot, a hero on the planet. Number 9, Julian Assange. Whether he is a hero or not is another question, but the United States negotiating a plea agreement with him in June. He is now in Australia, no longer in custody. He pled guilty in the federal court to 1 count of conspiracy to disclose classified national security defense documents. He's the WikiLeaks guy, you may recall. He pled guilty, brought that long-standing odyssey when he is in the custody variously in countries around the world, never back here in the United States, but brought to justice ultimately by virtue of a plea agreement that has him accomplishing a time-served result. He's now back in Australia, and that episode now over in America. 10, 11, and 12 are the charges of various people. You know them well. Recently, Luigi Mangione for the brutal, vicious murder on the streets of Manhattan of the United Healthcare CEO. That continuing to be a subject of a huge amount of focus in America. We'll talk more about that in the future. Sean Diddy Combs, we've talked about him only briefly. Federal sex trafficking allegations against him, likely going to trial sometime in the coming year, changing not only the course of his career plainly, but also once again underscoring the importance of the rule of law when it comes to basic human rights, to be free from sex trafficking, the victims of his coming forward more and more. And Brian Kohberger, a name you may not recognize, he is the alleged murderer in the November of 2023 University of Idaho horrific murder. Federal and state charges there as well. Luigi Mangione, also federal and state charges. Brian Kohberger, as a result of a lot of pretrial activities of recent times, in the news a lot. That case probably also, at least the state case, going to trial in 2025. The alleged murder, as to all three of these, Kohberger and Mangione and Combs, we recognize, we embrace the notion that they are not guilty. They are innocent until proven guilty in a court of law by competent evidence beyond a reasonable doubt. All three of them charged in major cases of just this past year. And then we have things right here in the state of Wisconsin. We've got this continuing issue related to Act 10, 2011, changing the ways in which a variety of teachers and nurses and prison officials and state employees have actions as members of unions and can assemble. That Act 10 basically stripping of them of their rights. Many cases in the state of Wisconsin challenging that. Right now, recently, back in the courts, Judge Jacob Frost recently finding that portions of that Act 10 law from way back in 2011 violate the Equal Protection Clause because there are two categories of people identified in that. And a major issue in the state of Wisconsin right here at home for those of us who are residents concerned about not only the actions of our Supreme Court, but the lower courts here. Judge Jacob Frost in the Dane County Circuit Court finding just recently that Act 10, at least in part, is unconstitutional, plainly not the last story there. And finally, dramatically, horrifically, the Madison shooting at the Abundant Life Christian School. 2 dead, a teacher and a young student as well. 6 hurt in addition to that. And of course, the assailant, the shooter herself, apparently committing suicide there. Again, all of those kinds of things happening right here in the state of Wisconsin, in the United States of America, in our world. Our continuing commission here on Amicus, a law review, to bring you those major stories in the rule of law and justice and government. Stay with us for all our future broadcasts. Have a good weekend, everybody. Have a good and peaceful new year.